Good afternoon, everyone, and welcome to this midweek show with myself and Karen. Thanks for joining me this afternoon, Karen.
You're welcome.
We are going to speak about the Cost of Living Tenant Protection Scotland Act, which has just been passed by the Scottish Parliament, and it's a temporary act that's been put in place, which I'm sure the majority of landlords and investors have heard about and had dealings with over the past few weeks since it come into force. So we're going to break it down today, Karen, and talk about the rental caps and obviously the moratorium on evictions, which is currently in place. And I've got a lot of facts and things that we've drawn from the government website and things. So if anyone's listening today and wants to interact live with us, we're live, and wants to ask questions on what we're discussing, I will try my best to answer them and have a discussion about them. We've got a lot to get through today, but I think obviously the first thing to cover, Karen, is the cost of living. The cost of living is what has brought this forward, and I think my first question to you would probably be, you're doing frontline lettings and feet on the ground type thing. So the cost of living, have you seen this starting to have an effect on the rental market?
We have, yes. Since we came out of COVID and lockdown, the market has just been incredibly busy. We've had our choice of tenants basically because there's just been that many people applying for the same property. Since we have gone into the rise in living costs, we've seen the market slow down. Now, there is still a good amount of interest in rental prices. So as long as landlords have a property that's in a good condition and it is on at the right price, then they are still getting a good amount of interest in it. But the pricing for properties is something that we're having to watch just now. People are obviously being a lot more conscious of what they're spending just with the rise in utilities, food, everything just now. So it is something that we're seeing have an effect on both the rental and the sales market.
Yeah, and of course it will, because I mean everybody's tightening their purse strings and watching what they're spending, and obviously because the cost of fuel and utilities, and do you know what I mean, and even food and things as well. I heard on the radio this morning about food banks and things having just the demand of food banks and things just now has surpassed what's ever been in previous years. So so that's inevitably going to have a knock-on effect, and we're going to see that coming through. Although, I mean, it's not to say that things aren't going to come to a grind to a halt with lettings. We've come from such a busy period, of a high basically. So yeah, to keep that in mind, and the pricing structure, I think, is a good thing that you brought up there, is that pricing property accordingly is a really important thing, and in line with the current market conditions, and that is important. But anyway, back to today's topic. So yeah, the Cost of Living Tenant Protection Scotland Act. As I say, this was passed by the Scottish Parliament. It's a temporary act, and it temporarily restricts landlords from increasing the amount of rent they can charge private and social tenants, as well as student accommodation. Now, this places certain restrictions on enforcement on evictions for residential tenancies as well. So they balance these restrictions with safeguards for those landlords who may be facing particular cost pressures or financial hardship. So the rent cap itself, now, which applies to in-tenancy rent increases, has initially been set at 0%. There's no leeway with that, and that is from 6th of September 2022 up until at least, this is it now, it does say at least the 31st of March, so no sooner than that. Ministers have the power to vary the rent cap while this is in force. Enforcements on eviction orders resulting from the cost of crisis are prevented over the same period of time expected in the numbers and specifying circumstances. And damages for unlawful evictions, now this is an important one, damages for unlawful evictions have been increased to a maximum of 36 months worth of rent. The measures can be extended over two further 6-month periods. So unlawful evictions and not going by the rules of the temporary legislation that's been put in place can cost you dearly if not followed and adhered to, as stated obviously by the Scottish Government. So please bear in mind that you do things correctly, and if you're unaware of what that is, speak to someone who does. So Karen, have you seen any effects of this temporary legislation being put in place have an effect on lettings and things at the moment, or do you expect it to?
Thankfully, we've not seen too much of an effect just now. We're still reasonably in the early days of this, but obviously when it comes to a point where if a landlord is looking to sell the property or is looking to move back into it, obviously it's far harder to do that now. Even when we had our COVID restrictions in place temporarily, I felt had more flexibility within that. There was still scope for notices, but with this, there's very small chances that you can basically serve notice.
Yeah, I mean, obviously, notice is a final and last resort. But I think obviously with the rent caps and things, we spoke on the show yesterday. Jim and Perry and I were talking about obviously mortgage interest rates and things. And as those change, then that would a lot of landlords, as we've spoken about before, don't increase their rents predominantly or obviously in intervals throughout tenancies. Usually they just let it run and change it when the tenancy changes. But in instances where mortgage interest rates and things are going to have an effect on their outgoings, then that's when landlords and investors and things might want to readjust their rental values in line with maybe the current market conditions if it's going to be slightly higher. In this situation, they can't do that. And at this point, we've got obviously mortgage interest rates changing, and we've got a freeze on the rents that you could charge. So that's where I've had a few obviously come through to me, and that's what the position that they're in. But unfortunately, at the moment, there isn't really a way around that until we wait until the temporary legislation time is up, which is 31st of March. And then we'll see what happens from there. Speaking about the temporary cap on rent increases, so obviously from the 6th of September 2020, there is a temporary cap on rent increases during existing tenants. So the cap is set at 0%, as I've said, and it's expected to stay in place until the 31st of March. This is part of emergency measures put in place to lessen the impact of the cost of crisis on people who rent their home in Scotland. So it goes hand in hand with the cost of living crisis and things that they've deemed it necessary to put this temporary legislation in place to safeguard tenants in their current tenancy. And this means from the 6th of September 2020, you cannot increase your rents unless you can prove that there has been an increase in certain costs before you can increase the rent on the basis that their costs that these costs, and then you will need to apply the rent to the rent officer and things. So there's a long process where if you could prove otherwise through speaking to the rent officers and things, but that would be a really long process and probably would end up in a quite unsuccessful, in my opinion. Any rent increase notices given to your tenant on or after the 6th of 2022 would obviously would not be valid. But obviously beforehand, rent increases and things go through your rent officer. Have you seen? I mean, it's not something we typically see, Karen, throughout tenancies that we change the rental value, increasing it. Is it something that you have experienced recently? It's not something that I see predominantly.
There's not really, yeah, like you said before, there's not very many tenancies that we have that have had rent increases during their tenancy, unless they have been in for a long time, like they've been in the property for a few years, and obviously the price has gone up since then. Obviously, the market's increased. That's really the only time. Or obviously, we had quite a few when the local housing allowance went up. There was a few rent increases that we did just to obviously bring it up to date with the current housing allowance for our whatever properties that we have: 2 bedrooms, 1 bedrooms, 3. But obviously during tenancies it's not particularly common to have. So we've not had too many issues with landlords as it is facing this as a difficulty. But obviously, like you say, with the with the increase in interest rates, that is obviously what's causing the issue with it that landlords are facing.
Yeah, that's the main issue where I see it having an effect. And most tenancies are covered by the rental cap. The rent cap applies to the most existing private tenancies, and that includes obviously the private residential tenancy, which is the current tenancy in place for any new tenancies in Scotland from, was that December 2017, Karen?
Yeah, December 2017.
Yeah. Assured tenancies and of course short assured tenancies, which were the model of tenancy prior to December 2017, and we still have quite a few that run on that as well. Obviously, longer term tenancies but any new ones are on the private residential tenancy, which is shown PRT. These are all covered by the rent cap. It also applies to many social housing tenancies and student and college and university halls and residences and purpose-built student accommodation. So there isn't much tenancy that it doesn't cover. So I mean, it's across the board. Tenancies which are not covered by the rent cap, some assured tenancies where rent increases are controlled by the contract. So if your tenant has an assured tenancy where the way their rent will increase is set out in the contract, and this provision of rent increase is still legal to enforce, then their rent will be able to be increased in the way agreed in the contract, and that's on some assured tenancies, not short assured. Regulated tenancies under the Rent Scotland Act 1984. These tenancies already have a strong protection in place, and the rents for these tenancies can also increase only every 3 years. Common law tenancies, and this includes agreements like agricultural tenancies, lodger agreements, where your tenants live within a home, and with the exception of student tenancy agreements. So yeah, that's just a few of the tenancies which are not covered by the rent cap, but they will be very few and far in between in comparison to your private residential and your short tenancies and things as well. So yeah, anybody unsure about whether their tenancy is covered by the rent cap, please obviously drop us a message, ask us, but the likelihood is you're more than likely going to be under a private residential tenancy or a short assured tenancy. So rent increase notices issued before 6th of September. So this is before the emergency legislation come into place. So if you give your tenant a valid rent increase notice before the 6th of September 2022, the rules which were in place before these temporary changes were introduced will still apply. So for a rent increase to be valid, you need to pay attention to the fact that it says any valid rent increases, you must have used the correct type of rent increase notice for the type of tenancy. So you must have given the tenant the correct amount of notice for the type of tenancy and followed all the other rules set out in the law by rent increases for that type of tenancy. Now, you can find out more about that on the government websites and things. If it's on the private residential tenancy rent increases at the moment, you need to do written notice. Is it 3?
Yeah, so tenants require written notice and 3 months worth of notice before the rent increase can be implemented. So you have to give them that in writing with the appropriate documents if you are planning on doing a rent increase. So like we say, if that was implemented in place before the 6th of September 2020, then obviously your notice will still, obviously you can put the rent increase in place. Yes. That has to be being done prior to that. So obviously 3 months notice is obviously going to run for a little while. So obviously if it does have an overlap, if it's served beforehand, you will be fine. However, if it's after that, then the rent increase cannot be implemented.
Yeah, no, that's correct. In any instance, obviously, if you are serving a notice to increase the rent, your tenant may have the right to challenge the rent increase if they think that it's not in line with current market conditions, or if they think it's obviously too much in comparison to what the property they live in. They can contest that, and they can do that by applying to the Rent Service Scotland or indeed the Tribunal. So always make sure if you're doing rent increases when it's legal to do so, that you are doing it in line with the current market and with the advice of a professional who knows the market and the current rental values that are achievable and realistic within the market, what the market dictates. Because if you try and implement too high, you'll risk pushing your tenants out the door, or indeed they can contest that, and it's a long, laborious process if you end up in that for.
And the thing is, as well, if you have a good tenant that's looking after the property, they're paying their rent, you don't want to hike up their rent and, like you say, push them out the door, and then you've got costs of finding a new tenant. Whether they work out, obviously, hopefully they do, but they don't always. So obviously you run the risk of pushing potentially a good tenant out the door if you hike up the rent too high.
Yeah, definitely. That's something that you want to avoid, especially if you've got a good tenant in place, because the cost of then having to do the whole process of maybe touching things up in the property, reletting, and all those costs involved are going to probably be a lot more than what your increase. was. So, just a second, I'm just looking at comments coming through. Okay. Any comments, guys, stick them in there. We will have a look through them and answer any questions that we can as while we're doing the show. This brings us to the temporary moratorium, or the pause on evictions. Now, from the 6th of September 2022, again, there is a temporary pause on the enforcement of evictions. Now, this is part of the emergency measures put in place, again, to reduce the impact from the cost of living crisis on people who rent their homes in Scotland. Now, the pause applies if you gave your tenant notice on or after the 6th of September 2022, telling them you want to end the tenancy. So anything on the 6th or moving forward from then, it's not valid. If you gave your tenant a notice before the 6th of September, telling them that you want to end the tenancy, and you did not apply to the tribunal for an eviction order before the 28th of October, tribunal cases which started before the 6th of September are not affected. Okay, so much like the rent caps, obviously beforehand things will still play out as they should, as long as things were done correctly in the first place. Now, the eviction pause is expected to remain in force until, again, at least the 31st of March 2023. The Scottish ministers can review the emergency measures if the situation changes during that time. So the eviction pause could be extended for up to 2 further 6-month periods. We don't know how that's going to pan out until we get to that stage, or closer to that stage. We'll maybe get a little bit more of an inkling of how that's going to proceed. So what do you do if you need to evict your tenant? Karen, do you want to run through a wee bit about what we need to do if we need to evict a tenant?
Yes, so you can still give your tenant a notice telling them that you want to end the tenancy. If your tenant doesn't move out by the date of the notice, you can apply to the First Tier Tribunal of Scotland and Property Chamber for an eviction order.
Yeah.
The tribunal will decide whether to issue an eviction order, just as it would have before if the emergency measures come into force. So you can still serve it, but obviously it's up to the tribunal, basically, if your claim is valid enough to justify having
they will have to review that, yeah.
In the notice. So if the tribunal issues an eviction order, sheriff officers will not be able to carry out the eviction while the pause is in force, except in a few certain cases. So the maximum delay for enforcement of an eviction order is 6 months after the eviction date order is issued. So even if the pause is still in force.
Yeah. So that's basically how that works. But a word of warning to people is that there are strict legal processes that must be followed to evict a tenant. And not following these processes, it could result in you being charged with a criminal offence as the landlord and the owner of that property. You must continue to follow the correct legal processes to evict your tenant. And the processes will depend on the type of tenancy, again, that you're on, and that comes down to the private residential tenancy, short assured tenancies, or indeed an assured tenancy. So there is different procedures for each of those tenancies depending on what you have in place on your property and with your tenant.
And what will say, tribunal, when you get to the point of having to go to the tribunal, they will pick apart every case that is there. So if it is a process that you are having to go through, please make sure that you're taking every precaution to make sure your documents are correct, the right procedures are being followed, because if not, it will just be a waste of time for yourself, unfortunately.
They will really scrutinise what you send through to them, down to not just dates and things and correct paperwork, but spelling and things as well. I mean, they're quite meticulous, and they don't take any prisoners. So be careful that your paperwork is correct. If you are a landlord and doing it on your own, please seek some professional help in doing so, whether that's a letting or management agent or even a solicitor, just to make sure that you have got things in place, because you could get quite a far way down the line through the tribunal process and they might pick up on something and it could set you back a lot. So just make sure, like you say, you do things properly, as it will be extremely scrutinised. So evictions that are not affected by the pause, effectively, that they've put on evictions. So the eviction pause will not apply if you are evicting a tenant because of the following reasons. Now, if they have engaged in antisocial or criminal behaviour, now that is one of the top ones that obviously, if that is something that you could prove, then eviction should be fairly simple to do. And one of the most important ones, I think, because if you have clearly got antisocial or criminal behaviour going on in a property, you should be in any instance allowed to evict. You will need to be able to provide evidence of that. If there's antisocial behaviour going on, then there needs to be a diarised timeline of this antisocial behaviour, whether that's reports from neighbours or the tenant themselves, or noted by the managing agent who's dealing with things. Records are so important. If anybody associated with the let property has been associating with someone who has relevant criminal convictions, or they are behaving antisocially, again, that's something that notice could still be served on. But again, I would stress that you need to have the correct evidence and things to follow up on that. If the property has been abandoned, abandonment of the property, again, although you have a property that's been abandoned and there's ways and means of establishing abandonment of a property, which will hold up in a tribunal hearing that you have followed certain measures and things to establish abandonment at a property. Even though you've done that, you still need to serve a notice. So you serve a notice to the property and obviously do your correct, obviously, records of that, whether that be obviously through recorded delivery and sheriff's officers and all the rest of it. Please make sure you do all that correctly. If the eviction moratorium will also not apply when the tenant is being evicted because the let property is being sold by the lender. If an eviction order is granted by the tribunal for these reasons, then the eviction can be carried out as normal. So the tribunal, although these situations are obviously grounds for eviction still, you need to provide evidence and the tribunal needs to be in agreement. And all of the usual requirements for using one of these eviction grounds will apply. And if none of the above grounds applied to the tenancy agreement under which your property is let before the emergency measures were introduced, it will not apply during the eviction pause. So eviction one, it can be a bit of a minefield if you're not too sure about what you're doing. So again, speak to the right people and make sure you've got the right information. The tribunal, as we say, has quite a complex system, and they will be quite meticulous with things. So let's have a look at tribunal cases, and tribunal cases that are started before the 6th of September. So this is pre the emergency legislation, if there is tribunal cases that were already in place. So sheriff's officers can still carry out evictions where an eviction order has been granted if the tribunal was issued an eviction order before the 28th of October 2022, as long as they served a notice to your tenant before the 6th of September, which is when the pause or the moratorium came into place. If you've applied to the tribunal before the 6th of September and the case has been accepted by the tribunal, then that's fine. And you've served notice to your tenant before the 6th of September and applied to the tribunal before the 28th of October, which is just prior to that. So these dates are important because if your eviction notice doesn't fall within this time frame, then it will not be accepted. Evidence you'll need to give to sheriff's officers, you will need to provide sheriff's officers with evidence to show that the eviction has not affected, is not affected by the pause, and you'll need to provide them with the notice that was served on the end of the tenancy, to end the tenancy, sorry, the notice of acceptance from the tribunal, so to say that they've accepted that, and of course your order of eviction as well. Have you experienced a lot of people looking to do evictions because of the situation at the moment, Karen, or what kind of scenarios have you come up against in the past weeks and indeed maybe months?
So thankfully there's not been too many. Most of our landlords are aware that this is a situation that is in place. There's not a lot of restriction, there's not a lot of leeway with it, as we've covered within this show. So most of our landlords are aware of the situation and are accounting for it. I think at the end of this, we will probably see a bit of a rise in notices for landlords that have not been able to implement them during this time. So it'll be interesting to see what happens when the pause is over.
Yeah, which hopefully will be the 31st of March 2023. So yeah, we spoke a lot about obviously the evictions there and how to do things correctly, or the importance of doing things correctly, and if not, to speak to the right person. That brings us on to what could happen with unlawful evictions. Technically, if you're not doing things right and you're enforcing an eviction unlawfully, it's important to use the correct procedure when you end a tenancy. Like, I cannot stress how important that is. And if you do not do this, you may be breaking the law. And ultimately, it is the law like any other law. You might be committing a criminal offence if you go to the property, for instance, and change the locks and keep the tenant out of the property. That, in the current situation with the pause or the temporary legislation in place, and any other time out with that is never okay. Yeah, I was going to elaborate. It's never okay. You cannot do that. They have a legal right to be in the property until notices are served within the guidelines of the law. Make life uncomfortable for a tenant and feel that you have forced them to leave their home. Things like, I mean, and I know this may sound ridiculous, but cutting off people's water, their gas supply, and electricity supplies. This can be classed as harassment, and is something that should not be carried out to any property that has a tenant in place. And also, physically removing a tenant from a property is against the law. Only a sheriff's officer may be instructed to do this. And I don't mean manhandling them out the door. I mean, like, to be present and physically enforce that they go is not something that a landlord should be practicing. That is what sheriff's officers are in place for. If your tenant has been unlawfully evicted, they can apply to the tribunal for civil damages. So if you carry out an unlawful eviction, then the amount of money which can be required to pay to the tenant will be based on their monthly rent. And the tribunal can award damages to the former tenant for an unlawful eviction of between 3 times the monthly rent and up to, wait for it, 36 times the monthly rent. So that is not a bill that you would like to have enforced on you, and it will be legally enforced on you, depending on the circumstances and what the tribunal deem necessary. So please be careful. The tribunal can also decide to set the damages at a level lower than the minimal amount if it considers it appropriate to do so in the particular circumstances or the individual case. Now, if you're a joint landlord with people, the tribunal may make the order against all people. Some of them are only maybe one, depending again, obviously, on the circumstances surrounding the situation. The tribunal must send a copy of the order awarding the damages to any local authority where you are registered as a landlord, and Police Scotland as well, so that they can decide if any further action should be taken. So not only are you going to be obviously served with this fine, you will also, your landlord registration could be put in jeopardy, and you will also be put in front of the Police Scotland, and if they deem it necessary to follow through on any further charges, then you have that to contend with as well. So unlawful evictions are something to be very, very careful of, and do not try to take things into your own hand would probably be my best advice. Any take on or feedback on that, Karen?
Yeah, obviously it can be frustrating for landlords at this time, but making sure that you are adhering to the restrictions that are in place, if you are going through any processes like this, making sure that your documents are all done correctly. And no, unfortunately, you cannot just kick people out as much as you may want to in some situations. It's not something that can be done. So making sure that you're following the precautions and taking the right measures in the first place during this time. Yeah,
definitely. I mean, these are things that, as worst case scenario, when you end up in a situation where you feel like, if you feel like any of these kind of options are what you need to resort to, but our advice is never do that. It's against the law. And again, if people are in a situation where they don't know what to do in terms of a tenancy, and where they legally stand, then I mean, a lot of this information is all on the government websites, or if you are members of landlord groups and things, they will be able to provide you with that, or speak to a qualified local agent or letting agent or managing agent, and they should be well versed in what to do in any situation, or know where to look for the right answer. So please rely on people who are in the know. That was unlawful evictions. So the paperwork and things, wrongfully terminating the tenancy as well. So these are two different things. Unlawful evictions are what we just covered. Wrongfully termination of tenancy is back to obviously serving paperwork and things correctly. And if your tenant has a private residential tenancy, which a lot of what we have at the moment is a private residential tenancy, as we said, Karen, those come into force December 2017 and onwards. And think if a tenant obviously is in a private residential and think they were misled into the tenancy, they can apply to the first tier tribunal for a wrongful termination order. Now, the tribunal may make a wrongful termination order if it decides that the landlord or the agent or whatever misled the tribunal into issuing an eviction order when it shouldn't have. So that's providing misinformation to the tribunal to serve a termination order, and then the tenant comes back and says, "Oh, wait a minute, that's not right." Goes to the tribunal and says, "Well, this is my take on things," and they will review that. And if they find that it's maybe been served wrongfully, then or the tenant's been, or they've been misled, or the tenant's been misleading, in the whole termination of the tenancy process, you could find yourself in hot water. Wrongly made the tenant, if you've wrongly made the tenant leave the property, for example, if the tenant, if you gave the tenant notice and telling them to leave the property because of a particular grounds for eviction, then, and it was not true, then this would mean that the tenant had moved out because of this, and then that would be a wrongful termination. One, I think, which is quite common, is I'm going to move back into the property, or I'm going to sell the property, and you serve notice on those grounds and do not move into the property or sell the property, you will then be in that position where you've wrongfully terminated the tenancy, and could find yourself obviously down the line in trouble for doing that. If the tribunal issues a wrongful termination order, you may be told to pay the tenant who has applied for the wrongful termination order a payment of up to 6 months equal to the monthly rent. So whatever the rent is, times that by 6, you could be fined up to that amount. And again, if you are a joint landlord with other people, the tribunal may make this order against all parties, some of them, or maybe even just you as individual, depending on how the circumstances surrounding that and how the wrongful termination was executed. If the tribunal makes a wrongful termination order, they must also send a copy to the local council, and again, your registered landlord registration for your local council as well. So again, with the unlawful evictions, it's not just down to a fine. You could have your landlord registration in jeopardy, and also the fact that you're breaking the law can come back to bite you, and you will feel the repercussions of that. So it can be a bit of a minefield if you don't do things correctly, I think, is what I think is the main thing I would like to stress. Karen, would you like to add anything on to what we've covered today in terms of the rent freeze and the evictions, which are the two main parts, obviously, of this temporary emergency legislation?
Yeah, so I think just obviously if this is a situation that is having an effect on you, make sure that you seek the right advice, whether it's from a letting agent or just somebody that knows what they're talking about. Obviously, there's a lot of information online on the government websites, but speak to somebody. It can be quite confusing, and it can be a bit of a minefield going through all these different pages for it and maybe not finding the right information. So if you are struggling with it, please contact an agent. And I think, again, this comes down to the importance of making sure that you find yourself the right tenant in the first place, so you don't end up with these issues throughout the tenancy.
Yeah, I think always, every time we do shows and talk about things like this, I think a lot of the times it always comes back to it. There is a prevention for circumstances like this. And I think it always comes back to finding the right person in the first place. It's such a key part of the whole letting process, and just makes things so much more pleasant, and it makes the whole process more enjoyable for landlord, agent, tenant, and really all round what everybody wants. But yeah, be careful when you are dealing with things, especially through this period of the emergency legislation being in place up until, like I said, March 31st, 2023. Please be extra careful and how you are executing yourself as a landlord or indeed an agent as well. But I think the last bit we covered there is unlawful evictions and ending the tenancy without the correct means and measures and paperwork in place is so important. I think generally throughout any part of any tenancy, not just this period of the emergency legislation being in place. But yeah, thank you so much for joining me today, Karen. It's good to get a wee bit of insight, because I know you do a lot of obviously frontline lettings and speak to a lot of tenants and landlords and things, so it's good to get your insights on that. Like I say, any people watching this in the rerun or have any questions, stick them in the comments. We will come back to you, or indeed you could speak to us direct through social media or on the office. So that is us for this afternoon, guys. Again, thanks for joining me, Karen, and we'll see you next time.
See you later.
Thanks. Bye.